Hello, TikTokers. Welcome to Real Law Talk, where I've gotten a ton of questions about CPS and speaking to attorneys. ACS in New York City, and from my understanding across the country, they have this tactic, and it goes as follows. CPS workers don't speak to attorneys. What does that mean? That means that the CPS worker will call you, despite the fact that you've retained an attorney and given him the contact attorney's information. Here's the legal issue. If an attorney contacts someone else's client, another attorney's client, without that attorney's permission, there are disciplinary proceedings that can be brought on the bar. CPS workers are not attorneys. We can't file complaints against them at the bar. They're not subject to our rules. So there's this sort of what they believe is a loophole to attack parents with. And there's a very simple solution. You, as the parent who has the attorney, you simply say, speak to my attorney, and don't answer their phone calls, and have your attorney return the call every time they call you. And eventually, they give up. But this tactic has been going on for 17 years that I've been doing this, and they also don't allow parent attorneys in what's called attorney-client conferences, or child safety conferences, they're called. CPS workers will do anything to keep the parent away from the attorney, especially during the investigation phase. What they want to do is speak to the parent, gather all the evidence they want, gather all the information, make up all the lies they want about the parent during the investigation phase, and then go to court and say, okay, now you can have an attorney. It is more critical to have an attorney during the investigation phase than in court. Because if you've spoken to CPS, by the time to get to court, you're done. When my clients see petitions filed against them after they've spoken to a CPS without an attorney, they are shocked what's in the petition. So do not speak to CPS. And that's Real Law Talk.